the 2014 to 2015 Experian Jones Day Moot Court Competition for UC Irvine School of Law. Thank you all for attending. My name is Jen Stevie, and I'm the president of the Moot Court Board this year. We're so glad to have you all in the audience, and I want to direct you through the schedule of events tonight. If you have your program, I'm going to direct your attention to the schedule of events directly after the summary of the case. As you can see, we will begin with oral argument shortly. The dean will introduce the judges, and the judges will process down the aisle and be seated. The bailiff tonight, Andrena Bergen, will be acting as the court marshal and will announce the seating of the court. We ask for security purposes that you remain seated through the entirety of the oral argument. The judges will exit afterward, and we ask that you remain seated afterward, and we will begin the presentation of the Best Brief Awards. For oral argument purposes, we have Aaron Benmark for Petitioner and Jacqueline Shepard for Respondent. Aaron Benmark will also reserve time for rebuttal. Each side gets a total of 20 minutes. At the end of presenting the honors to the Best Brief winners, the judges will return after deliberating on the case, and they will announce the best oralist for this year's competition. I would now like to introduce our beloved Dean, Erwin Chemerinsky, who will introduce our esteemed panel of 3 circuit judges. Thank you all.
It's my great pleasure to welcome you to our 5th annual Experian Jones Day Moot Court Finals. I want to start by thanking our sponsors, Experian and the law firm of Jones Day, who very generously sponsored this competition from the very beginning. I also want to thank all of the students on the Moot Court Board. You have their names towards the back of the program. This is a student-run competition. They choose the problem, they write the materials, they recruit the judges, they organize every aspect of it. So could you please take a moment and join me in thanking the Moot Court Board for their tremendous work in making this happen. I want to thank Professor Rachel Krosky-Roberts, an advisor to the Moot Court program. Tremendous amount of work goes into just the logistics of an event like this. I want to thank our staff, especially Mary Germain and Brittany Rodriguez, for all they did to make this happen. One of the choices that UCI Law School has made from the beginning is to use a real case that's now pending in the Federal Court of Appeals and set it into the Supreme Court. Many schools have problems that the students make up. And there are, of course, inherently problems if it is a made-up record. So our school uses a real case. This is a case that's now simultaneously pending in both the United States Court of Appeals for the Second Circuit and the United States Court of Appeals for the District of Columbia Circuit. This is titled here, ACLU versus Clapper. It's quite likely that this is a matter that will go to the United States Supreme Court in the next couple of years. In your program, you have a detailed description of the problem which will be argued about. We're very fortunate to have 3 terrific Federal Court of Appeals judges from all over the country to be judging this Moot Court Finals. You have their names and their circuits in the program. It's Judge Allison Duncan from the United States Court of Appeals for the 4th Circuit. It's Judge Susan Graber from the United States Court of Appeals for the 9th Circuit, and Judge Carlos Lucero from the United States Court of Appeals for the 10th Circuit. And with that, I'll turn it over to the bailiff, and we can begin.
All rise. Oyez, oyez, oyez. The Supreme Court of the United States is now in session. The Honorable Chief Justice Carlos Lucero and Justice Susan Graber and Justice Allison Duncan now presiding.
Good afternoon. The court is ready to hear arguments in the consolidated cases of ACLU versus Clapper and Kamen versus Obama. Counsel, are you ready to proceed?
May I reserve 5 minutes for rebuttal?
You may, counsel.
Your Honors, the NSA bulk telephony metadata program is an unconstitutional infringement on the petitioners' and all Americans' rights to privacy and expressive association. This program operates against everybody who owns a cell phone in America continuously, indefinitely, without probable cause or even reasonable suspicion. This program is a violation of the First and Fourth Amendments of the Constitution, and to prove that, I intend to make 4 arguments here today.
Well, you're going to have to prove to us or persuade us that you have standing in the first instance, correct?
Yes. The first argument is that we do have standing under the First Amendment of the Constitution. And the reason that we have standing is that in this case, unlike the previous case, Amnesty International, we actually know because of the Edward Snowden revelations that the data that the petitioners use, the metadata from the cell phones, has actually been collected by the NSA.
What do we make of the taxpayer standing cases, though, that suggest that having an interest in common with pretty much everyone else is insufficiently personalized?
Well, in this case, there is personalized standing because, sorry for the microphone problem. There is particularized standing for these particular plaintiffs because their data has actually been collected. So we aren't talking about a generalized collection of all Americans, but in this case, our petitioners' data has been collected, is being stored, and is more likely than not being searched by the NSA.
How are you harmed by the collection of data that potentially no one will use or ever see? How is it different from a telephone book?
Well, the reason that it's different is that we know that this data is being used, and based on how
You know that you or your client's data is being used?
we know with virtual certainty that our client's data is being surveyed because we know exactly how this program operates. We know.
Then why isn't it just the access rather than the collection that's the violation?
Well, the access is a more direct violation of, especially for First Amendment purposes, but we believe the collection itself is also a violation. And in this case, when there's virtually no difference between the collection and the access.
Well, there is a difference, isn't there? The collection is a seizure of information. The querying is a search, and they take place at different times and they with a different level of generality. So why shouldn't we analyze those separately?
Well, I think for the purpose of standing, there really isn't a difference as far as showing that there's been an actual particularized injury. The way the program works is they take these 300 seed individuals, and from those 300 individuals, they run a 3-hop search through the metadata database. And as we've seen in the lower court record, 1 million people can be accessed from a single search. And so if they're running 300 searches on each of which is able to get to 1 million people, it's nearly impossible that all the data in the database is going to be collected.
Counsel, this information that you're talking about is information that is already in the possession of telephone companies, correct?
Yes.
So, under the third-party doctrine, does that mean that the phone company has the cause of action and therefore standing, and not any individual customer of the phone companies?
Well, for third-party doctrine, that's a Fourth Amendment issue. The standing issue on trial here, I think, is confined to just the First Amendment standing.
Let me ask you a question about the First Amendment if we get to that point about substance. What role does the First Amendment claim play that is different than the Fourth Amendment claim for which your clients clearly do have standing?
Well, I think the role is that simply it's an additional violation of their constitutional rights on top of the Fourth Amendment violation of their constitutional rights.
What different result or what different remedy or why do we need to get there?
Well, if you're correct under the principle of constitutional avoidance, if you rule that there has been a Fourth Amendment violation, there's likely no reason to reach the First Amendment violation.
Not constitutional avoidance, that's picking one clause over another, but it's still, I just wonder what what the necessity is of getting to that claim.
Well, the necessity is that there has been a constitutional infringement of the petitioner's rights, and I think anytime there have been constitutional infringements, there is a necessity to get to those claims.
Counsel, I'm still trying to get past standing, the First Amendment standing issue, and I'm trying to see how, with respect to the mere collection of the data, you're in any different position than the plaintiffs in Amnesty, because the Snowden disclosures, as I recall, only dealt with one business entity. Isn't that correct? How do you extrapolate from that to a certainty that your data was collected?
Well, again, according to the Snowden inquiry, every Verizon customer's data was collected, as well as of the major other telecom companies that has been revealed in further congressional hearings since the Snowden revelation. So,
Well, counsel,
since our
let me understand this. The telephone company is collecting the very data that you are concerned about, correct?
yes,
Now let's analogize that to a filing cabinet. If somebody's filing cabinet is taken, that's a seizure, correct?
yes.
Now, where's the utilization of the information?
The utilization do you mean the utilization by the government?
Yes.
That
is different from the utilization by the phone company. That is to say, in the record where you can prove, for standing purposes, that the situation is different.
Well, I think different from the amnesty. Oh, different from the phone company itself. Well, again, the phone company's rights aren't the ones that are necessarily being violated in this case. Again, it's because of the First Amendment injury to the petitioners, which is caused by the fact that they're having additional surveillance put onto them because of their association with individuals.
But that's the point. What different surveillance than the phone company records themselves?
Well, the difference is that they're
Keeping records of the number called, the amount of time consumed during the call, and probably somewhat more extensive information in terms of rate charges between calls and information that is not being gathered in the metadata. I'm just trying to make sure, for standing purposes, that that your clients stand in a different position vis-a-vis the government than they do vis-a-vis the phone company.
Well, I think the difference between the standing is that the phone company, or between the government and the phone company, is that the phone company is not attempting to put anybody in prison based on their associations with other people, whereas the government is doing this as part of national security to chase down terrorists.
And isn't that a fairly legitimate reason? Have we not established that as a special need in the balancing analysis that we generally employed in such cases?
As far as the Fourth Amendment claim is concerned?
Yes.
Yeah, so as far as the Fourth Amendment claim is concerned, we don't believe special needs doctrine can be used to justify such a sweeping search, because special needs doctrine is generally limited to very specific circumstances. For example, responding to a direct terrorist attack in the McWade case in the subway bombing. Here, the government's attempting to use special needs to justify collecting records of every single person in America continuously and indefinitely. So it's.
But isn't that just one of the facts that gets factored into the balancing analysis, given the potential scope of the harm?
Yes, it does get factored into the balancing analysis, and we believe that in this instance, this balancing analysis has to favor not using special needs. If the government can justify conducting continuous, never-ending surveillance on every single American, utilizing special needs doctrine, then special needs doctrine could be utilized to justify practically every search and practically every seizure that the government wants to do. It seems like the exception would swallow the rule if you were allowed to call a special need on every single individual in the United States of America.
I'd like to follow up on the Fourth Amendment question briefly. Has the doctrine or the rule or the test of an expectation of privacy or a reasonable expectation of privacy outlived its usefulness as a benchmark? It seems to me that we're living in an era of data dumping of all kinds voluntarily, not just our phone data, but really TMI about almost everything on social media. whose reasonable expectation should we look at, or should we replace that test with something else, and if so, what?
Well, I think the reasonable expectation of privacy test is sufficient to protect people's privacy, and I think what's important is to note where the third-party doctrine works and where the third-party doctrine fails to work. And in this case, I think we're seeing a failure of the third-party doctrine, and to that extent, we think Smith should be cabined or even overruled so that this type of search is not constitutional.
What rule would you put in place?
Overrule, because we would have to actually attack that, would we not? Because the search in Smith was actually more individualized and focused than what we have here, which is somewhat diffuse.
Yes, we don't believe that you have to overrule Smith v. Maryland in order to rule for the petitioners. We think that Smith v. Maryland is a case where you're dealing with a single individual, a single pen register.
That's precisely my point.
Exactly.
Here, you may at the end of the day have a single individual, but it extrapolates into something that is so huge as to be almost meaningless, doesn't it?
I believe, yeah. I think in this case, this is distinguishable from the case in Smith sufficiently, where in Smith we're just looking at one individual, and in this case we're talking about using that one individual to justify conducting surveillance against every single human being who owns a cell phone in the country, and this surveillance...
What specific rule would you have us adopt? If you were writing the opinion, what do you want it to say?
Well, what I would say is that third-party doctrine at least needs some sort of subpoena or a warrant, something that's responsive to an actual crime that's happened, like we had in Smith, rather than allowing justification for a dragnet or a sweeping general warrant against the entire
But
population.
doesn't that exist at least at the stage when the query is initiated? Isn't there some sort of a distance review at that point?
A very, very minimal distance review. Basically, there are 300 names. The 300 names are never actually approved by the judge. Really, the judge approves the entire program. And the NSA can run those...
That approval is ongoing, is it not? Does it not occur every 90 days?
Yes, it is ongoing approval. However, it's not particularized to the individuals who are searched. And of course, the collection of the data has been improved against every single individual in America. We believe that you can't approve that type of general warrant against every single individual in America and stay within the spirit of the Fourth Amendment. This is at least less protection than the founders would have had at the beginning of, when the Fourth Amendment was written.
They didn't have mobile phones either.
They didn't have mobile phones, correct. So the type of spying that the NSA is doing would be unimaginable to the founders when you look at the way that they interpreted and envisioned the Fourth Amendment applying.
Does the fact that the program applies to all citizens equally rather than to discrete groups cut in your favor or against you?
Well, I think it cuts in our favor because it's being enacted against everybody. This is a general warrant. This is not a warrant that has been put out against individuals.
Generally, the type of gravamen of the complaint in these type of cases is that certain groups are being selected out, as Judge Graber noted with respect to the analogy to taxation, for example, and that there is where the infirmity lies in carving out these kinds of exceptions. And here, all of us we are told, basically making certain sacrifices, if you will, in order for the common good, that is to say, to catch the bad guys. And unlike a murder in a discrete case, this is the kind of crime that can literally wipe out a society, its democratic institutions. It can take out the Congress. It can take out the White House. It can take out our court. Isn't that a different species of crime that we have to look at and perhaps develop new jurisprudence to address?
Well, I think the problem is, of course, there has always been and there always will be the threat of terrorism. And the threat of terrorism on the level that you're speaking of has existed at least since the beginning of the nuclear age. I don't think we can do away with all the protections of the Fourth and First Amendment merely because there's a grave threat to the nation.
Well, but wait a second, not so quick. I mean, you haven't persuaded us, or at least you haven't persuaded me yet, that you even have standing, let alone persuaded me that all these protections have been thrown out. I mean, there are plenty of safeguards in this system, are there not?
There are, Your Honor, but I would question how valuable those safeguards are if the government can achieve a program that allows them to put every single human being in the country under surveillance.
Except it's not surveillance of the kind that many of our previous cases have dealt with. The cases like Berger and others dealt with content, with actual conversations or information. And this is at a level of generality that has no content, essentially. So does that matter to our analysis?
Well, Your Honor, I see I'm out of time. May I respond to your question?
May go ahead and finish your answer, please.
In this case,
That is in a reasonable amount
yeah,
of time.
of course. In this case, even though specific content of the type that you would normally think about in these cases isn't being drawn, I do believe that the amount of data that they're able to get and the way that they can aggregate this data to create kind of a portrait of somebody by looking at all of their metadata and their entire social networks creates a content and a level of intrusion into their lives that is unconstitutional and should not be allowed to continue. Thank you.
Mr. Chief Justice, and may it please the court, I'm Jacqueline Shepard on behalf of respondents. Since its very conception, the United States government has had to be mindful of balancing two of its greatest responsibilities. On the one hand, protecting the individual rights of citizens, while on the other hand, protecting the very country that affords us those rights. The government's metadata program was created with exactly that balance in mind. And today, we stand before you to ask that you dismiss this case on the grounds that, one, the metadata program does not violate Fourth Amendment rights to privacy, and two, petitioners have failed to show standing under the First Amendment, but even if they could, they can't show that this program. Yes.
Explain to me just how the program works so I can make this standing and constitutional determination. If I wanted to protect my privacy from a call, could I run down to the local Costco and use or somewhere, wherever you in this area in Irvine, sell cell phones, and for cash, buy a cell phone with an anonymous number and make a couple of calls and then throw the phone away?
Yes, you could, in that those numbers will still be collected, but they won't necessarily be attached to your identity.
Does the existence of alternative methods, such as the one that the Chief Justice mentioned, or the use of email or messengers to carry handwritten notes, whatever, does the existence of alternative means have any bearing on our analysis under either the Fourth or the First Amendment?
No, it does not. The issue here is that turning is the third-party doctrine you guys were discussing earlier, in that turning over this information to a third party voluntarily is what creates no expectation of
If
privacy.
we go back to the standing question for just a moment, do you make any distinction for purposes of your argument between the collection of the data and the ability to mine the data?
No, both of those are not, there's no standing under either one of those for petitioners in this
Either
case.
one. So is it your contention that the government could bug my chambers, and as long as they didn't actually listen to anything, it wouldn't be violative of the Fourth Amendment?
No, that's not my contention.
So how do you draw the line?
The difference here is that this is a mass collection of telephone numbers. It's numbers that are used as tools for phone calls. And
So the government bugs everybody's chambers in my building. Does that help you?
you're talking about bugging, which is collections of the content of your conversations. And this program is collecting just the numbers used to make phone calls and make connections.
And is that the distinction that you rely on for your standing argument?
That's a major distinction. The respondents rely in this case on the fact that petitioners have not shown an actual harm to them. That you were correct in bringing up that the phone company may actually have better standing under this case. They may be able to show a loss in call volume. They may be able to show letters from people who stopped using cell phones once they found out that the government was doing this.
Well, I just want to get back to my first question and that is, given that you concede that I can go out and buy this cell phone and make calls and bypass the whole program, of what validity is this program other than some purely feel-good program for the American public?
First of all, not everyone will go out and buy throwaway cell phones.
But the crooks will, right? The terrorists will. They're not.
And drug dealers and a lot of other people who do that. Yes, you're
All the
correct.
people that you want to catch will do the
They're-
type of thing that all the rest of us won't do. And but if I'm going to go call my friend, I'm not going to go buy a cell phone to call my friend. and then throw it away.
There are two purposes to this program. The first being identifying individuals, which you could route around that by buying a throwaway cell phone. The second purpose of this program is to help understand networks and understand calling patterns of people engaged in terrorist activities.
Well, my question is,
The network, which is the Chief Justice's point. You have a half a network or maybe no network at all, which seems to reduce the justification for the program.
If my understanding of technology is correct, the throwaway phones still use the same networks. They just don't necessarily immediately connect to your identity. However, if we were to find that you were making phone calls to a Yemenis safe house, it would be possible, using the information that these numbers have, to trace back where that phone was purchased and possibly who purchased it if you used a credit card.
well,
But
I-
you'd need
I
a
said
warrant
cash,
for
right?
that, would you not, counsel?
Yes, in
Okay, so why not require a warrant for the earlier phases of the same investigation? It seems to me that your argument would apply equally to every well-intentioned investigation of crime that the federal government engages in.
There are two important things to consider. One being that the special needs doctrine applies when it is impracticable or redundant to get a warrant, and in this case it would be impracticable. Often the NSA is following very specific trails of calls or grasping at straws of information, and therefore if every single time they found one call, they had to go before the court again to get a new warrant.
You can't be saying that it is permissible not to comply with the Fourth Amendment because it's a challenge, or expensive, or time-consuming. That's
No.
not what the special needs balancing test goes to, is it?
No, the special needs balancing test measures the nature of the individual's privacy interest against the government's need and efficacy of the program.
And you indicated, I think, one of the distinctions you see is that this program is non-content, is a non-content-based program, is that correct?
Somewhat.
Doesn't it also convey geographical information? Can't one assess where one is based on the trunk identifier?
It does, and that's actually one of the most important parts of this program.
So it's just a little more than telephone numbers, isn't it?
It is, except that it's not attached to your identity, and therefore, unless you fall under an investigation or contact someone already under an existing investigation for terrorism, your particular information is of no use to the government, and it's against the statute to use it for any purpose.
Well, that's sort of taking the analysis by the tail, isn't it? If you're guilty, it'll matter. If you're not guilty, then you don't need to worry about someone collecting your data in the first place. Is that how one proceeds about a Fourth Amendment analysis?
As you stated earlier, the amount of information that is being collected makes it so that if you were to see a screen with all of your own personal information on it, you wouldn't even recognize any of it. It's numbers that attach to trunk identifiers, but even a trained NSA agent who knows everything about this program wouldn't be able to attach this to anyone or anything.
You say that it's Smith v. Maryland that protects you and should guide us in our analysis, correct?
Smith and Miller.
All right, Smith and Miller. Is Smith really applicable here, given the breadth of the discovery that's taking place?
It's
I
absolutely.
didn't use the word fishing expedition, but it's pretty close to that, right?
It's absolutely applicable in that, in fact, phone numbers were more personal during the time of Smith. Nowadays, my 14-year-old daughter doesn't even know her own phone number. The fact is that we use our phones for so many things, and we know that it is following us. If it's in our pocket, it will track us.
I'm going to ask you then the same question I asked opposing counsel. Is the test that we have used traditionally for some number of years, reasonable expectation of privacy, the right test for the present day or not? And if not, what should replace it? Because it seems to me that if it's simply what does the next generation do with information, how is that a constitutional principle to say, well, we no longer really have any expectation of privacy that's reasonable because we give it all away?
Your question brings up 2 points. One is what we would do in domestic cases. The other is what, in this case, which is foreign intelligence collection, would be appropriate. In the case of domestic cases, you may be correct. There may be some issues. However, there are warrant requirements in place for collection of a lot of information when it comes to domestic searches. But this court in Katz and Keith, and then the lower circuit courts in several cases have brought up that there is an idea of a foreign intelligence exception and that falls under the special needs doctrine and weighs more in favor of the government in such cases. Foreign intelligence is so difficult to get. We can't send a warrant to Yemen and ask Yemenese phone companies to give us their records because we found a suspect in Yemen. This type of information is so difficult for us to get and is so vital to saving this country in times when people would try to destroy it. As you said, these types of attacks go to the very core.
Ends up, if one party to the phone call is not in the United States, we wouldn't find it to begin with, would we?
If they call into the United States, we would find it.
Okay, but there has to be someone answering the phone or making the call from the United States, and so it's that person. It's always domestic on one half. Every time I call my sister who lives in Toronto, it's trapped, right?
If your sister is under investigation for terrorism in Toronto. So, no, the program, you're only going to be queried, your information is only going to be looked at specifically.
Taken the seizure has occurred, though. That information is in the system, correct?
Everyone's information at this point is in the system.
From your perspective, what does the ACLU have to prove in order to meet the substantial burden test under the First Amendment?
They need to be able to prove that their interest is higher than the interest of the government. The government is able to prove.
Well, that should be easy enough, don't you think? I mean, surely any organization can demonstrate that their traditional notions of privacy have been totally compromised by this program.
They need to be able to prove an actual harm. They need to be able to show some sort of, and not evidence.
Are we talking about standing now? We've gone back to standing?
We're talking about the harm under the First Amendment.
Burden test that would be under Alvarez.
The First Amendment allows for the government to show that if there's a compelling state interest that can't be achieved under more substantially less restrictive means, then it hasn't violated the First Amendment. In Roberts v. J.C.'s, this court said...
Precisely our earlier point, correct? Alternative methods to gather the data.
And the respondents maintain that there are no alternative methods.
Why couldn't you just go to Verizon and say, we want information regarding number 718 and so forth, and please provide all information regarding calls from that number?
The phone, if
you don't have to go to this big black box in Utah or wherever it is, you just go right to the phone company.
With the metadata program the way it is now, to be able to search every carrier, Verizon, AT&T, Sprint, to be able to search every carrier with the push of a button with that phone number that's come in from Yemen allows us to see everyone who's calling them and who those people are calling. If we look at what happened in Paris, we have a woman who was the go-between.
That is being articulated before us here. The huge amount of privacy that every single American has given up in the hope that the government will get information that has not been otherwise compromised in the manner that we were asking about earlier.
During the 9/11 attacks, one of the suspects was in San Diego making calls to a known terrorist outside who was helping orchestrate this attack. Right. Because we didn't have this program.
Now the terrorist and the person in San Diego know that the metadata program exists. The damage has been done in that sense. And now, if they wish to have the same communication, they're going to have to resort to alternative means, correct?
The question then becomes, if terrorists' technological advances are moving forward, should we bind the hands of our government and not allow them to use the same technology against people that would hurt our country? The point is that the government has tailored this program so narrowly that only specific search terms already related to existing attacks are allowed to be used. They have no interest in the average citizen's trip to the store or whatever is happening.
I'm not sure that you've answered the Chief Justice's question, or if you have, I haven't understood it. And that is, why would it not be sufficient to have a list of targeted individuals or phone numbers or both? There may be 786 of them or whatever, and work from those numbers with phone companies outward. And that would leave the vast majority out of this metadata process. Why isn't that a sufficient means and more targeted and potentially subject to a warrant?
It's not nearly as useful, and in your mind, it makes sense to find one number and follow each number that it's called. But if that number calls from a foreign country or a foreign enemy that we already know about, and then we have to query, or we have to get a warrant from Verizon, and we get their numbers, we see who they've called, then we have to go to Sprint, then we have to go.
That gets back to
The speed with which,
Justice Duncan's question, which is that a constitutional argument that's sufficient to say, well, it's a lot more convenient, it's cheaper, and it's faster, and therefore it's okay?
that's not a constitutional argument. That was the answer to your question as to why that doesn't work as well. The bigger answer to your question is that because we do not have jurisdiction over people in other countries or foreigners, foreign enemies from outside that are trying to do harm to those of us inside, we can't treat them the same way we're allowed to, or we need to treat criminals in our country.
I'm sorry, I still don't understand how that's getting to the question of why you can't pursue a given phone number as far as you can.
The point of
And then
the,
get a warrant to pursue it once the investigation becomes more focused.
the point of the program is trying to find these associations. If, with the way you suggest it, we would only know the existing suspects we already have. We would never discover anyone else. We would never discover the people they're calling. As I brought up before, the example in Paris, they had a go-between who was helping orchestrate. The orchestrators called her. If they had the program we have, if known suspects are calling a middle man or woman in that case and using that person to help orchestrate and make the phone calls out, they can't route around it if you have a program like this.
It seems to me that you are making plaintiff's argument for them to some extent in terms of, in their First Amendment argument, because you're explaining how government knowledge of phone numbers can potentially create this picture of relationships which would affect individuals well-intentioned, like whistleblowers, wouldn't it? Or confidential informants.
This court has maintained that the right to associate is not absolute. Your right to associate with known terrorists who are actively working against our country is not an absolute right that you have. You may come under investigation if you do something like that. It doesn't mean you're...
The right to associate with the ACLU is protected, and the question is whether that type of associational right, as alleged in the complaint at least, is significantly chilled because of the desire of persons to bring confidential information to that organization.
Because there are actually no identities attached to any of these numbers, they don't bring up, a screen wouldn't even show you that it was the ACLU. The NSA has no reason to even be looking at the ACLU in particular versus anyone else out there unless they are representing a known terrorist. And if that's the case, then they may come up under the search, but that alone does not violate their constitutional rights to associate.
The necessity of speed, because I understand your argument that by the time you go out and get a search warrant and then pursue that for a while and then 3 days later pursue another search warrant, the damage has been done. The bomb has been dropped or whatever. Have we outgrown traditional concepts and notions of First and Fourth Amendment freedoms in the United States when it comes to trying to defeat terrorism?
The First and Fourth Amendment are still important, even in regards to terrorism, which is why this program doesn't collect every single person's identity. That would be faster. If we knew everything about every person and we could search your house when we thought you had called a terrorist, then that would be easier.
I mean, as Justice Duncan said, I mean, you get a number, you just punch in the computer number and it'll immediately, the phone company data on that customer shows up immediately, faster than you and I can even ask the question.
But that is against the law and against the statute, and it's against the design of this program. And the IRS has just as much information on you that it's not allowed to use for nefarious purposes either. To do away with an entire program because there's the possibility of harm, our police department would be gone by now. We have tons of government programs that have the potential to do harm, and yet if they do more good than harm, which this program has been narrowly tailored to do, then it meets the balancing tests.
So if we have burglaries happening in Dean Chemerinsky's neighborhood, It seems to me that you're arguing about some kind of jurisprudence that would allow us, or allow the government, the police, the well-intentioned police department, to start tracking all calls into that neighborhood, innocent or what have you.
That would be a domestic crime, and that doesn't fall under any of the foreign intelligence cases that have been decided so far.
So that's the exception. It's
Yes.
purely foreign, and you're representing to us that this program does not trap intra-state calls, that is domestic calls.
Unless they are between people that are already under investigation for terrorism.
The minute that you have a suspect, you automatically get all of the data, right?
The minute that you have a suspect, you are allowed to query using certain search terms that may narrow and bring in more people. With a court order from the FISC.
How you can tell me that this is a foreign program when in fact you are using all the domestic data for the very purpose that you tell us is prohibited because it's domestic. I just think you're chasing your tail on that argument.
The necessity of the program and the efficacy of the program are what outweigh the personal liberties in this case. The government has, I'm out of time, may I finish my sentence?
Please, it's same admonition.
Quickly. The government has gone to great pains to make sure that they're collecting information that is helpful to them without attaching identities and using it against people. Therefore, it does not violate Fourth and First Amendment rights. Thank you very much.
I think we have 5 minutes of rebuttal time.
Your Honors, my opposing counsel made a lot of the fact that this is merely a foreign intelligence program, and there's a difference under the Fourth Amendment for a foreign intelligence program and a domestic program. However, two things defeat this argument. First, this program is in place against calls that are made entirely within the United States, that do not even go out of our boundaries. So it is effective domestically in many cases. And second, this program, the doctrine that they're trying to use, the third-party doctrine, it does not distinguish between foreign intelligence programs and regular domestic security programs such as the police. This is a doctrine that if it's followed to its logical conclusion, that you have no privacy interest whatsoever in any information you give to a third party would allow even a...
That interests me a lot because in Europe, for instance, the right to privacy in one's personal data is extremely highly developed, as I'm sure you know. All of the signatories to the European Union have signed on to a convention that protects privacy in people's correspondence. This country has proceeded on a different track. We've argued in a number of contexts that the more information is always better. The cure for too much information is more information. Aren't you arguing the flip side of that coin in terms of saying that we should do more to protect privacy?
Absolutely. We should do more to protect privacy. And I think the way our relationship with data has changed over the last 30 years has created an environment where the U.S. government, by querying the so-called third-party data, and more importantly by aggregating it, the collection of this data in these huge databases and then the algorithm-driven searches of that data, allows the government to create a very, very particularized, intrusive look into a person's contact and behavior.
That's one version of it, but let me posit this opposite scenario. Let's assume a malintended terrorist seeking to destroy an entire section of the city of San Diego. Under this program, within seconds, the program will run all its algorithms, and you have certain suspects that might stop this heinous crime. You're suggesting that we resort to traditional means of running out, finding a judge, getting a search warrant, typing out a section of probable cause. By then, the deed's done. I'll ask you the same question I asked your opposing counsel. Constitutionally, our doctrines outrun their utility when it comes to modern-day terrorism?
No, Your Honor, and for this, I'd point to the fact that the government has yet to allege a single instance where this program was actually helpful in catching a terrorist that wouldn't have been caught by traditional surveillance.
I would really appreciate it if you would accept the validity of his hypothetical and address it. Mm-hmm. Say that actually has happened.
or is going to happen?
Absolutely.
How do
And
you respond to that?
my response would be traditional surveillance is more likely to catch this terrorist than this program is likely to catch this terrorist. But even if there is, say, one instance where this program would be effective, you're still balancing the privacy of every single human being in America, because everybody needs a cell phone at this point, against.
Balancing it against, in his hypothetical, wiping out a part of San Diego. Would people might not voluntarily wish to give up some of their rights to use a mobile phone to protect half the city of San Diego?
Well, again, I don't believe that this type. At some point, you could say the same thing for any crime. Would people be willing to give up their rights during a crime wave when people are being murdered, when there's a school shooting going on and dozens of people are being killed? There are many instances where people's lives are at risk, and we have had to.
This is not placing a substantial burden on members of the ACLU. This is placing an equivalent burden on members of the ACLU that differs neither in quality nor grade or time as to any other American. And therein is where I run into complications in your argument on particularized standing, on Fourth Amendment search, on the protection of liberty interests under the First Amendment, for example, because we're kind of communally in this pot, and we're trying to find our way out of this mess.
Yes, well, it is true that this program's in place against every single person, but each person suffers particularized harm by the program, by being unable to conduct their normal relationships with people without worry of government surveillance. The ACLU, may I finish my thought, Your Honor?
Don't be, our time has already run. We didn't even give Justice Graber a chance for a question. Justice Graber.
Okay. I'm informed by your questions.
Your Honor, the ACLU does suffer particularized harm in this case because it represents terrorists and has an even larger stake in the protection of general rights, and has even more interest in having their conversations protected because of attorney-client privilege. And generally, I believe every American has standing, and every American has their constitutional rights at stake in this case. Allowing the government to conduct continuous, never-ending surveillance would be an infringement and a dangerous precedent to set for the future. Thank you.
Thank you, counsel. And thank you to the parties for bringing this most fascinating case to the lap of the court. The court will be in recess. The case is submitted. Counsel are excused. Thank you.
In a moment, we will get to the awards for our best brief winners, but for 1 minute, let me commend to you the importance of this program. The Moot Court program instills confidence in our competitors. It yields competence, and it cements collegiality. One of the missions of UC Irvine School of Law is to create and train real-world problem solvers in the legal profession. That is precisely what this program does. Our two competitors tonight are surely talented, but I assure you they weren't quite that good at the beginning of this program, much less their 1L year. As a fellow competitor, and as all of the fellow competitors on the board can attest, this is a challenging program. It is time-consuming, it is heart rate raising, and it is a blast. So because it is such a wonderful program, it also takes a tremendous amount of effort, not just on behalf of the 14 members of our board who are 3Ls and trying to balance their life and schoolwork as a 3L, not to mention job concerns and the like, but not only does it take the efforts of the Moot Court board, but it takes the entire coalesced efforts of this local legal community. Because we have such a high number of competitors, largely driven by interest in the chance at arguing before an esteemed panel such as this, we have an enormous number of competitors every year. This year alone, we had close to 60 competitors, which required 30 briefs to be graded, required over 60 attorneys and state and federal justices and judges to judge 18 separate days of oral argument. And for all that, we only had 2 professors at the head as our advisors, Dean Erwin Chemerinsky and Professor Rachel Croskery-Roberts. Can you please give them both a round of applause for their wonderful work? I'm going to invite Professor Rachel Croskery-Roberts to join me in just one second, but let me give you a brief word of the type of work that they do in passing on what we've termed institutional memories from one year to the next, so that we can avoid as many glitches as possible as we relearn every rising board how to run this program. Dean Erwin Chemerinsky has put in tremendous work to especially in our bench brief committee, who wrote the tome that the judges used to navigate the thorny constitutional issues of this year's moot court issue. He advised on so many last-minute questions and questions of technicalities that only Dean Erwin Chemerinsky could answer, and we appreciate him eternally for that. And Professor Rachel Croskery-Roberts, if you could join me, we will begin handing out the awards. Let me say about Professor Croskery-Roberts, she has given us more advice than we could do well with. We are ever grateful for her continued presence in the board's life and being able to coordinate efforts between the board and the administration in producing tonight and the almost year that runs up to each year's event.
Just one thing. So in the program, in our behind-the-scenes program, I was supposed to just give a general thank you to the board, and I've decided that that's not good enough. So I know their names are in your program, but I really feel compelled to speak their names to you. They've said they work hard. You don't know the half of it. Many of these people have done nothing but moot court. They live, eat, sleep, breathe moot court, and still somehow manage to get the rest of their lives pulled off, barely. So I just want to say a special thank you in front of a very large crowd to Tim Allen, Aaron Brynoldsson, Sheila Chen, Ann Conley, Caitlin Emmons, Michelle Ferguson, Matthew Germer, Rachel Khalili, Will Nen, Margot Poimaru, Andrew Spank, Claire Stanley, our wonderful Jen Stevie, and Nick Yeager. Thank you.
So we had many competitors. I don't want to keep you here all night. Surely the judges' deliberations won't take that long. I won't name all of them. But you do have the list of all of our hardworking competitors in the 2014 to 2015 competitors section of the program. The page after that has our finalists, whose names I will read. For our octa finalists, or top 16, we had Aaron Adams, Ava Baji, Kristen Brzezinski, Ryan Fisher, Colby Johnson, Coral Lopez, Kelly Mikola, Christine Robles. For our quarterfinalist, Nefi Acosta, Dylan Kornbluth, David Rutan, Elizabeth Tissot, and our semifinalists, Yashina Burned and Ronald Park. If you could please give a round of applause to those 16. And now the part most of our students have been waiting for. This year, as a number of years in past has happened as well, we had 2 teams tie for runner-up best brief. So we will actually hand out 6 plates tonight, 4 to the 2 teams that tied for runner-up best brief and 2 to the team that won best brief. The award to the best oralist will happen after the judges return and announce the deliberations as to who that award should go to for this year. First, so for logistics purposes, if your name is called, please do come up and receive your plate from Professor Croskery-Roberts, and then we will wait for the judges to continue and finish their deliberation. So first up, I'm just going to delay this as long as possible because I can see you all agitated in the front row. I do want to say the brief writing component alone takes a tremendous amount of time. So, in tied for runner-up best brief, our first team is, oh, sorry, I couldn't read that. It's Coral Lopez and Christine Robles. Sorry. And next, we have tied for runner-up Best Brief, Jacqueline Shepard and Ronald Park. And finally, we have for Best Brief, Yashina Burns and David Rutan. Thank you to all of our competitors for your hard work and for representing UCI law here, and for all the judges who came locally and from very far away to preside over the many rounds of oral argument for this year's competition. At this time, we will have a brief time where we wait for the judges to deliberate, and we will cue you when they come back in. Please stay in the room until that is finished, and after that is concluded, we'll have a light reception out front. Thank you all.
All rise.
Sorry. I think we're okay. Well, I'm sure you are probably worn out from waiting, but can you imagine if you were waiting for our substantive decision on this case? In writing. Might take 6 months. We're sorry for the delay in the deliberations, but we will not keep you waiting further. As you can see, extensive and careful consideration of the abilities of the two presenters, their style, their substantive approach, their response to questions, we came up with a tie. No, I'm just kidding. It really was almost a tie, but ties are there to be broken, and we have to make those tough decisions, and we wish to joyfully announce the recipient of the award this year as the best oralist is Aaron Benmark. And Ms. Shepard, you were terrific, and normally we would announce the runner-up and then the finalist, but somehow we thought that wouldn't work, would it? I mean, but you did a terrific job, and you are to be commended for your presentation as well. We are going to make a few comments about the style of argument and any comments that might be helpful to you and your career, but also to those of you who are students in the room, of whom I trust are many. And we'll begin, as we do in the federal system, generally in reverse order of seniority. So, Justice Duncan.
It was a pleasure to do this. These are always very difficult because the problems tend to be almost evenly weighted, which makes it fairer, but it also makes it more of a challenge to make a decision. You both, as Justice Lucero indicated, did a phenomenal job. I would just say a couple of things. First of all, I have to apologize because I think I was in everybody's line of sight. And so I was moving back and forth, and I hope that wasn't distracting, but I was trying to keep out of the way of your seeing the other judges, and it also makes it difficult not to talk over other people's questions. So you got a fairly hot bench, which tends to be the case, at least in my circuit. In fact, I've been told I can be a hot bench all by myself. I thought you did a wonderful job answering the questions. I like people to make eye contact. I like the yes, no explanation answers. Couple of things. Oh, another thing is, if judges are firing questions at the same time, I thought you did a good job of waiting, of not interrupting, managing to answer everybody's questions in the order in which they arrived. I would just mention something that I found troubling when I started arguing in federal courts, and that is hand gestures, because sometimes you can do this and you can do things with your hands that you may not be aware of. So hold something, and you're less likely to do that. And I don't have much to say. I would just caution, always be on guard against informality, and never, never, never think something's funny. Don't attempt humor or become colloquial, but just always treat this with the sort of reverence we think we deserve. You know what I mean. This is a process. It's not us, it's the court. And just treat the questions with the level of respect that you did, and I think you will do well. Thank you.
It's hard for me to see both of you. I don't know if you can see me, but I thought you both had tremendous presence, which is something that not all the real lawyers in our courtroom do. You both did better than a very large percentage of the lawyers that we see every day. So you should be very proud of yourselves for that. You used a wonderful voice, pacing, delivery. You were both excellent. One of the things that I particularly appreciated in the opening argument was that a yes-no question was answered with a yes. And then you waited for the next question. That doesn't happen enough to be that responsive. And I had a similar reaction as my colleague in terms of the slipping into informality occasionally. I think one of you said "you guys" at one point, which is not something that we normally hear in court. And it's hard because on the one hand, you want it to be a conversation. It's the most useful for everyone involved if you actually are talking to each other about the problem. So it's really quite easy to slip into that. And in some courts, that's perfectly okay. There are courts where the discussion is quite informal. You have to really take the temperature of the particular court and learn its culture. But that's the one piece of advice. I also want to say about the problem, I really appreciated that there was a real life problem. I think that's wonderful. This one may have been a little bit large to take on, but I do think that it's wonderful that instead of making something up, that there's an actual case that is involved. In future, it might be interesting for the judges to have the briefs of the finalists because, again, in real life, many of the questions from the bench are about the brief. Why did you cite this case in support of such and such? Or what did you mean by such and such in your brief? So that's just for future. But a wonderful experience. Thank you.
Well, I join in the accolade. The case itself is, as all of you in the audience could see, a case that presents deep philosophical and policy questions for all of us. And I thought the advocates could have done more in thinking deeply about the problem. You did a very good job of segmenting the questions. I suspect that confronted with this case in reality, the court will be just as torn as we were on the substance of the case, recognizing the intent and the purpose of the act, but also being faced with the obvious intrusion into the privacy and constitutional rights of all Americans. I thought my colleagues did a superb job of raising the problems around the question. Judge Graber with her question about taxation. After all, what's more intrusive into the privacy of Americans than filing an income tax return in which you disclose your children, everything about your life. And yet the court has said that every American does not have standing to challenge either the tax itself or the expenditure of the taxation. So I think that that's somehow related to these questions. Judge Duncan, in her questions, I thought did a very superb job, as well as focusing the issues for you. Were you preparing the case for argument 3 days from now? You'd have the benefit of the judge's thinking. So how do you go about in preparing for, in real life, arguments for the type of questions that you might get from the bench? That's called mooting. At all law firms do it. The quality of the mooting is going to depend on the quality of the mooters. And so as you look at your advocacy courses, it's, I think, good and important to think as deeply as you can about the case and then place it in the context of the argument. I join in a couple of remarks on style. I thought you guys were terrific, and while we may get to that level of discourse among each other at the informal level, you certainly do not want to do that before the court. I thought that the one remark at the closing argument was every American has standing. I think all of us focused in on that comment at the last argument. I'm not so sure I would have made that argument, especially right at that point, which is kind of points to the weakness of your case. But it really does, on the other hand, highlight the opposite of the correlative of the question, and that is, if every American doesn't have standing, then which Americans do have standing? Do you have to have an actual criminal prosecution before it rises to the level of standing? Do we have, as Americans, to have this heavy burden of intrusion on our lives in the anticipation that it's going to take 2 years to appeal a case before you ever really get to injury, etc.? So, with our thanks to the University of California Irvine Law School, to the very fine reputation that you're very rapidly building, we close the oral argument competition for the year and extend our compliments to the two of you yet again. Thank you.
Thank you. I want to thank all of you for coming to the 5th annual Experian Jones Day Moot Court Finals. The Moot Court program is a very important part of the law school, and the finals each year are really one of the signature events that we have. There's a reception outside, and I hope you'll all join us at it. I'd ask all of the award winners to join with the judges for pictures as soon as we finish now. I want us all to take a moment to thank our 3 terrific judges, Allison Duncan, Susan Graber, and Carlos Lucero. And finally, we should conclude by once more a round of applause for the 2 finalists, Erin Benmark and Jacqueline Shepard, who did such a great job here today.
Today's final arguments for moot court was terrifying, and yet I think the whole process was sort of such a good educational experience. It was kind of nice to culminate in this really nerve-wracking, in front of 3 amazing judges and everyone we know sort of experience. So even though it was terrifying, I'm happy that it's over, and it was great.
The finals today were pretty intense. The judges asked a lot of really hard questions that really, I thought, got, really focused on the hardest questions that the problem presented. So it was a really, really good experience, tough learning experience, but I guess I did okay.
The most valuable thing is sort of learning a case that well and then being able to do round after round, because each time you sort of learn it a little more and figure out what arguments sound good to a professional and what don't, and just really being able to hone. I mean, if I were to rewrite the brief now, there's a lot of things I would add or take out, knowing what I now know, because each round of oral arguments you sort of perfect the process.
I want to thank the Moot Court Board. Again, this is a student-run program for the most part. They picked a great problem. They ran in a really, really difficult and incredible process. I want to thank the judges. I want to thank the school, the administration, everybody who kind of helped put this together. And it's been sort of a surreal, wild experience, and I'm glad I took part in it.
This process has been really confidence building because it sort of, you're doing a long game exercise instead of just a short classroom exercise. And so it's been nice to be able to follow something all the way through and have the experience of something. It's a major case that's actually happening in the real world. So I've been able to talk to real lawyers about it, and it's definitely confidence building and makes me realize I can actually follow through on something and make it come out well in the end.